Sources of Hindu law. Today we'll discuss the sources to Hindu law here. Before we discuss the sources, it is important to understand the background to the Hindu law. Speaking of the background to Hindu law is a very old and ancient known system of law. It is 600 years old and it has passed through various phases, and from thousands of years, people used to live in Indian subcontinent by following the rules of Vedas. And later these Vedas became the laws in fact. That is why Vedas are called as de facto laws. And later, in the modern days, the Vedas have now been ratified and been codified into several laws. Now we do have the laws related to the Hinduism to regulate the Hindu culture. Uh, in 1955, Hindu Marriage Act was enacted, and 1956, Hindu Adoption and Maintenance Act and Hindu Minority and Adoption Guardianship Act, Hindu Succession Act was enacted. And later, the study of sources of Hindu law is a study of various phases of its development. And speaking of its applicability, to whom the Hindu law is going to apply, Hindu law is applicable to Hindu, Jain, Sikh, Buddhist, and any person who is born to Hindu parents. And Hindu law is not going to apply to someone who is a Muslim, who is a Christian, Parsi, and Jew. This is the applicability of the Hindu law. Speaking of the origin of the Hindu law is believed to originated from the divine law. It was revealed to the people. The law was revealed to the people by the God through the Vedas. Now, speaking of the sources of Hindu law, there is a primary source and a secondary source. In the primary source, we have Shruti, and then we have Smriti, and the third, we have Commentary and the custom. And in the secondary, we do have judicial decisions, legislations, and justice, equity, and good conscience. We'll discuss these sources in detail. Speaking of the ancient source of Hindu law, before the codification of Hindu law, the ancient literature was the only source of law. And the in the ancient source, the the sources is divided into four. One is Shruti, Smriti, Commentary, and Digest. The first source to the Hindu law is Shruti. Shruti is nothing but what was heard. Something which was heard is Shruti. And Manu defined Shruti as what was heard, and what was heard above, what was heard from above, from the God, is Vedas. And that is Shruti. What was heard is Shruti. Now, speaking of this, Vedas was considered to be the paramount source, and it is a primary source. They used to believe that sages of that time had so much of spiritual heights. They had so much spiritual heights. They used to communicate direct with the God, and that is how the sages used to get the Vedas. That is how the sages used to get the messages directly from the God. It is because of their spirituality. And then at times, the sacred law was revealed to them by the God Himself. And Shruti, in the Shruti part, we do have four Vedas. One is Rig Veda, Yajur Veda, Samaveda, and Atharvana Veda. Rig Veda is about the praise of nature, and then Yajur Veda is about the ritual, Samaveda is about the prayers and the mantras, and Atharvana Veda is a magic spell or incarnation. Now we have six Vedangas. Vedangas, first is Siksha, Kalpa, Vyakaran, Chandas, and Jyotish, and Nirukta. These are the six Vedangas. At the same time, we also had 18 Upanishads. The period of Vedas is approximately considered to be between 4000 to 1000 BC. The Vedas depicted the way of life of early ancestors. This is about the first source of Hindu law. And then we have the second source, that is Smriti. Smriti is nothing but what has been heard. Shruti is what was heard. Smriti is what was remembered. First, it was heard, and later it was remembered. That is the second source, Smriti. Smriti is second source to the ancient sources, and it is what has been remembered. And now, when we talk about Smritis, Smritis are based on memory of the sages. It is based on memory of the sages, and we do have two Smritis. One is early Smriti, other one is later Smriti. In the early Smriti, it is Dharma Sutra, which is between 800 to 200 BC. In early Smriti, it used to be in a form of prose, kind of a lesson. It used to be in a form of prose, and we have Gautama, Dharma Sutra, and Bodhyayana, and Vishnu. Speaking of the Gautama, it was the oldest text which dealt with the legal and religious matter, and Bodhyayana dealt with marriage, sonship, adoption, and inheritance. And Vishnu wrote about the criminal law, civil law, sonship, adoption, and inheritance. Then we have the second type in the Smriti, that is the latest Smriti, which is called as Dharma Shastra. Speaking of the Dharma Shastra, we have Manu, Atri, and then Vishnu, Harita, Brihaspati, Narada. They are the famous writers of Dharma Shastra. Dharma Shastra was in the form of poetry. It was in the form of poetry. The Code of Manu is treated to be the paramount authority. The Smritis by the Manu is considered to be paramount, and it's considered to be the more detailed Dharma Shastra. So this is the second source. Speaking of the first source, it is what was heard, Dharma Sutra. And once it was heard, it was later remembered. That is Smriti, what has been remembered. Here in the ancient, first Smriti, there it is 4 Vedas, 6 Vedangas, and 18 Upanishads. In the later Smriti, in the Smriti, there are two things: early Smriti, later Smriti. Early is Dharma Sutra, later is Dharma Shastra. Then we have commentaries and digest. Commentaries and digest are considered to be between 700 BC to 700 AC. All the Smritis, the next step after the Smritis, the next step in the development of the Hindu law was to composite the Smritis into the commentaries. And there were two famous commentaries. One is Dayabhaga, which was written by Jimutavahana, and Mitakshara, which was written by Yajnavalkya. The Dayabhaga was by Jimutavahana, Mitakshara was by Yajnavalkya. And there was also a commentary written on Manusmriti, which is considered to be the most honored commentary on the Manusmriti, which was written by Medhatita and Govinda Raja and Kuluka Bhatta. And then comes the last source to the primary source. And this can also be asked as a separate 10-mark question. That is, custom as a source to Hindu law. Speaking of this, we do have a custom as an ancient source of Hindu law. First thing is, what is custom? Custom is something, a practice which was there in existence for a longer period of time. So, Devanai Achi versus Chidambaram, it was in this case the court said for a custom to be valid, it should be ancient, certain, and reasonable. It was Section 3, subsection A of Hindu Marriage Act, which defined the term custom. It said, custom is something which was continuously observed, continuous and uniformly observed for a long period of time, and later which has got the force of law, and something which was being followed by the local group, tribal group, family, and something which is not opposite to the reasonableness, and something which is not opposed to the public policy. Speaking of the types, we do have certain types to the custom. Local custom is followed in one locality, whereas in a class custom is followed in one particular class of society. Family custom followed, it's binding on the members of the family. As early as 1868, the Privy Council said custom binding only on the members of the family, and later it is recognized as one part of the Hindu law. And we also have one more kind, which is not mentioned here. The one more type of a custom is a caste custom. So this is an introduction to custom. They say when the usage ends, the custom would begin. And then we understood section 3A, definition part of the custom and types of custom. Now proceeding towards the very important concept, what are essential requirements of custom? Speaking of essential requirement of custom, for a custom to be valid, it should be ancient. For a custom to be valid, it should be observed for a long time, as we get the reference in section 3A of the Hindu Marriage Act. A custom should be very old. It should have been accepted as law binding upon the people in the society. And then custom to be continuous. Custom must be continuously followed without any break. And it should be custom has antiquity of 400 years is what is believed in general. And then custom to be reasonable. It should not be something which is uncertain. It should be reasonable. It should be certain. And it should be as per morality. It should not be immoral, and it should be as per the public policy. It should not go against the public policy, and it should not be opposite to law. Actually, it is law. It should not be opposite to law, and the custom should be clear and unambiguous. So these are the essential requirements of custom. Now the question is proof of custom. Burden of proving the custom will be upon the party who is alleging it. Someone who is alleging it will have the burden of proof. And then coming to the modern sources to the Hindu law, speaking of the modern sources, we do have the first source, that is judicial decision. During the British regime in the country, Hindu law was administered by British judges with the help of the Hindu Pandits. They used to seek help of Hindu Pandits to interpret the Sanskrit text and to apply to resolve the disputes. So during the time of Britishers also, we used to find the reference to the judicial decisions. Judicial decisions. And then we have a case Lohar Amrit versus Joshi Jayanti Lal, where the concept of pious obligation, which was developed as a customary thing, was recognized. Now, fathers, after the death of the father, it is the responsibility of the son to repay the father's debts. That is the concept of pious obligation. Pious obligation. And then we have legislation, second source to the modern law, and modern sources to the Hindu law. Legislation, it has been now important factor in the development of Hindu law. Most of them are the direct reforming the laws of Hindus, and legislation has now become a potential source to the Hindu law. We have certain examples I've just quoted here. One is the Hindu Marriage Act of 1995, Hindu Minority and Guardianship Act, Hindu Succession Act of 1956, and we also had this Hindu Widows Remarriage Act of 1856 and Caste Disabilities Removal Act. These were the certain acts which regulated the Hinduism. And the last source of all the sources to the Hindu law is justice, equity, and good conscience. So what it says, in the absence of any specific law in the Smritis and in the event of any conflict in the Smritis, the reference would be given to the justice, equity, and good conscience. It was in the case of Gurnath versus Kamala Bai. In absence of clear Shastric text, the court has the authority to decide the cases on the basis of the justice, equity, and good conscience was laid down. Now, speaking to the last part of the sources to the Hindu law, Hindu sources is something which is deeply rooted in the ancient text and the customs, the legal precedents, and the legislations. And the last reference is given to the justice, equity, and good conscience. This is all about the sources to the Hindu law. If you need notes of the lecture delivered, or if you have special requests for any videos, you can contact to the number which is given in the you can comment. See you all in the next video.